Good morning. My name is Gregory Chikalian. I'm the hearing examiner for the Oil Conservation Division. This is the regular second docket of the month, scheduling conferences and status conferences. If we do have time at the end of these, I would like to continue our discussion that we started in December about feedback from the parties and council regarding any issues they may be having with the new systems put in place November 1st, but only if we have some time. Let's get on the record in case number 25771, 25772. Appearances, please.
Sorry, I'm just still pulling up my stuff. Jackie McLean on behalf of Permian Resources.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewburn Oil Company.
Good morning, Ms. Vance. You objected?
Yes, we filed an entry of appearance and objection in these.
Right. And the purpose of the objection?
Well, it's my understanding right now that the parties are in negotiations and working towards a resolution right now. And that's really where I'm at. As of right now, sorry, I was just getting some feedback from my client.
Okay.
Yeah, but as of right now, my understanding is that the parties are in negotiations. So.
Right. Okay. Ms. McLean.
Yes, I think we just like to set this case for a contested hearing at this point so that we can, get it on the books.
What's date? Yeah, we've sent out some dates.
Yes, we could do March 10th.
Okay, March 10th. All right, I am going to issue a pre-hearing order for March 10. Ms. Vance, if your witnesses have a problem with that date, file a motion, please.
Understood.
All right, so pre-hearing order will issue. Anything else, Ms. McLean?
Nope, that's it on that one.
Thank you very much. Let's move on to case number 3 on our docket. This is Permian Resources 25790.
Yes, Jackie McLean on behalf of Permian Resources.
Thank you.
And William Zimsky on behalf of Alpha Energy Partners 2 LLC.
Good morning, Mr. Zimsky.
Good morning.
You objected?
Yes, we're going to withdraw the objection because because Permian thought we owned in Section 12 and we had sold that in 2024. Informed opposing counsel this morning. We had an exchange of some emails and we'll be filing a motion to withdraw this morning.
Well, okay, very good. So Ms. McLean, how do you want to proceed?
I think that it would be best if we could continue this to the March docket because I think we're going to need a notice an additional party. And then we can present by affidavit at that point, but we'll need the 20 days.
Perfect. Okay. So you will continue this case. Freya, what is the March hearing by affidavit docket?
It's the March 5th.
March 5th. Okay. So hearing by affidavit 3-5. Anything further, Ms. McLean?
That's it in this
All right.
one. Thank you.
We're off the
Thank
record.
you.
Thank you, Mr. Zemsky. Moving on to Millstone Environmental Services 25801.
Yes, Jackie McLean on behalf of Milestone.
Oh, thank you.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, and we are objecting to this case.
Good. Thank you, Ms. Hatley, which is not normal for you. So how do you want to proceed?
We would like to maintain our objection. We are working with Milestone to enter into an agreement, but we aren't there yet. So we would like to maintain our objection and just follow your direction how the case should proceed.
So, Ms. McLean, when was this case filed?
Let me double check on that. Two, 0, 1. This was filed on December 12th.
Okay. How do you want to proceed?
After discussions with Conoco, we were hoping that we could be set for another status conference on February 26th.
Okay. So that'll give you, let's see, so proposals went out in November. So I assume, Ms. Hatley, your client got the proposals in November?
We did.
Okay.
And this one's a little different. This is not like a typical well proposal. would be involved. This is an increase in an injection rate. So it has to do with the already permitted SWD. And as you've become increasingly aware, there's always a lot of discussions about those. So that's why at this time, we're hoping if we set the status conference for February 26th, we'll come to an agreement and then we can proceed by affidavit after that.
So even after you come to an agreement, you'll still want to proceed with your application?
Perhaps.
Perhaps.
Yes.
Okay. All right. That sounds fine. It sounds like a good plan to me.
Okay.
Thank you, Miss McLean. We're off the record in that case. Moving
Thank
on to cases 5 through 7 on the docket. These are XTO Holdings 25807, 808, 809.
Yes, Jackie McLean on behalf of XTO.
Thank you.
Good morning, everyone. Ben Holliday on behalf of Riley Permian Operating.
Thank you, Mr. Holliday. Did you object?
We did object to these cases. Yes, sir.
Why?
This is an argument about the sufficiency of notice, and I think it's just a fundamental disagreement among the parties as to whether the notice provided was sufficient, and there are follow-on disagreements beyond that, but that's the primary matter that was addressed in XTO's filings.
Thank you, Mr. Holliday. So once you've resolved this disagreement over a notice, let's say that you prevail and new notice is provided, that won't resolve your overall concern, will it?
It's we need notice.
I'm sorry, what, Ms. McCann?
It's not Riley needing notice. It's we were not noticed.
Oh, you were
XTO was
not
not
noticed.
noticed. Yes.
The applicant wasn't noticed? I
Well,
don't
so
understand.
we have applied to reopen Riley's cases. There's 4 of them. There's 25807, 25808, 25809, and then 25868. And these are the Eagle and Marty wells. And when Riley went to pooling, they did not provide notice of the pooling to XTO, and XTO was pooled without receiving notice. So that's what this case is about. We believe that we should be actually given notice, but prior to being pooled into the spacing unit. And XTO actually wishes to participate in the spacing unit. So it would resolve a lot of matters if the cases were reopened and we were added as a pooled party, or not treated as a pooled party, but allowed to receive notice and then participate in the spacing unit.
In other words, participate through an agreement, through a JOA.
Yes,
Okay, not being forced pooled.
Correct.
Under the terms of the.
being
order.
treated as a consenting party.
All right. I understand now, Mr. Holliday. I was a little lost, obviously. So back to your contention that notice was is the first issue here to reopen these. There is a provision in the rule that allows a party to do what Ms. McLean is doing. Let's say that, is it your argument that if notice is shown to be correct by Riley Permian, that the case would then go away?
I believe this is directed to me, this Mr. Holliday.
Yes.
If Ms. McLean characterizes this as that no notice was provided, notice was provided by certified mail. The argument is over, did it go to the correct place?
Right.
And then again, there's follow-on issues related to XTO's acknowledgement of the pooling orders, elections, failure to fund in time. There's a lot of evidentiary matters in here.
Okay.
But yes, if we were to have that initial threshold hearing as to whether that notice was sufficient or not, that would be the lead domino that would take care of the rest of the issues.
Okay. And then in your perspective, Mr. Holliday, if notice was shown to be given or sufficient or whatever word you want to use, and the matter closed, how would you deal with XTO as a pooled party?
XTO would be treated as a non-consenting pooled party under the
I
orders.
see. Does XTO have the ability to negotiate out from under that?
I haven't been involved in all the negotiations. My understanding is this has been a long-running conversation between the two groups. I can't speak to what offers XTO has made. I know Riley Permian has made several commercial offers, or at least one, as a way to deal with this and provide an off-ramp, but that has been so far declined.
Okay, how do you, before I go to Ms. McLean, how do you want to, do you want to set a hearing for this? What do you want to do?
Our preference would be to set a hearing as soon as possible. I think this is a pretty mature issue at this point.
So you have dates that we've emailed dates to the parties. Which date are you looking at?
Oh gosh, I'm not sure that I received the dates. I know dates that are no-goes for people because of school spring breaks.
Well,
So
the
those-
dates that we sent out were February 10, March 10, March 24. Freya, while I talked to Mr. Holliday, will you see if he's on that email list that we, you know,
It was sent out via the typical listserv, which I believe Mr. Holiday is included on.
Okay.
Mr. Holliday, we do send out dates before we have these status conference dockets so that the parties can negotiate in advance for hearing dates.
Okay, yeah, well, I'll make sure that if I'll find that email. I
Thanks.
think the March 24th docket would be the preferred.
Okay. Okay. Thank you, Mr. Holliday. And that should give you plenty of time. That's over 2 months from now to work out the details on the notice.
So these are our applications.
Right.
We would request February 26th hearing date.
Okay. Do we have that as a list?
I believe what was it not?
Miss Freya, February 26th?
That's our normal status conference docket. We do have a contested hearing set on that date, but we also have 2 environmental NOVs that day, so we're not scheduling anything else.
Oh, I just saw it on the docket then as those. Then can we do the March 10th date?
Sure. Mr. Holliday, March 10?
We are currently set for a contested hearing
Ah.
for Powderhorn v. Avant on that date, I believe.
And you believe that's really going to go forward? Because so many of these just
Good question.
disappear.
That's a good question. It would be fine to put this on the trailing docket.
Okay.
For that date.
Good. March 10. We'll set it for March 10.
Great. Yeah. And I do think it's a very narrow issue of just the notice.
Right. Yeah, and Ms. McLean, I know that they're your application, so your preference would be heavily weighted in the balance. All right, so Mr. Holliday, anything further on these cases?
No, sir. Thank you.
All right,
Mr.
Yes.
Hearing Examiner,
yes,
may I ask a clarifying question?
please.
There's a case, the last case on the docket, 25868. Should this be included on the pre-hearing order?
Yes, it should.
Okay, thank you.
Thank you.
So I didn't understand what Freya asked, what you asked. Can you explain that?
When I had mentioned all the applications that were affected by this notice issue, I had included 25868, which is another Riley case for the Marty Wells. And so I think it would make sense to just do them all, consolidate them all for a hearing. Because it all involves the same issue of notice.
So Freya, why were 3 cases of the 4 consolidated, but not the 4th?
I didn't have any indication that it should be consolidated, except that it's the same parties and it looks somewhat similar.
Okay, but Ms. McLean, they're your applications. You do want them consolidated?
Yes.
And
I think it
Mr.
would be beneficial for the division to just hear the notice altogether.
On March 10.
Yes.
Okay, and
Well-
Mr. Holliday, and we have a 4th case which wasn't on our docket. You're aware of that case?
The Marty Fee case, yes, sir. Riley's preference would be that these would be heard separately because they do both involve notice, but the facts are different in these cases. And
But they
so
both
it
involve
might
notice.
not be the cleanest hearing. And I agree with certainly Ms. McLean's characterization that these will be focused hearings. You know, I don't think these will be multi-day hearings, but the facts are sufficiently different that our preference would be to hear them separately.
But it deals with the same issue, which is notice.
Notice is involved in both cases. Yes, sir.
Notice is involved in all 4 cases.
Yes, I'm sorry. Yes, both.
I knew what you
buckets.
meant, but I just want to be clear.
Yes, sir.
It's involved in all 4 cases. So make your argument of why the notice is different enough in this 4th case that it shouldn't be heard at the same time.
My understanding, and I haven't looked into the Marty Fee quite as much as I have the Eagle cases. My understanding is the initial question of whether the address to which the certified mail was sent is sufficient is the same in both cases. However, the conduct of the parties following that is different. how the parties interacted and elected or failed to elect and fund, those facts are different.
And those facts go toward notice, how they acted after after the mailing was sent out to this sufficient, in your words, address?
Yes, I mean, I think there's issues of actual notice, personal notice involved in here as well.
Okay. And Ms. McLean, why do you feel like that's not an issue?
I mean, I think that they're all issues, but to me, the underlying issue is the fact that Riley sent notice to the wrong address, and it's very easily shown that was wrong because in their own hearing exhibits, for example, they put 2 green cards next to each other, one to XTO, one to EOG. It's the same address. I mean, all those people are here regularly before the division. There's really no question that those should be the same addresses, right? So it's a very simple issue of notice that I think, precipitates all of the other issues involved. Riley needs to reopen these cases and actually give notice of the pooling to XTO. And I think handling that up front will streamline everything, and we can get into the weeds on everything else. That's fine. But I think, even just briefing on the notice issue might resolve things. We've done that previously before the division in cases for like there was a Rockwood and Colgate case. There's been many cases where this issue has been handled just by briefing. And, we could do that as a precursor and then decide if a hearing is necessary, so that we don't have to waste the division's time and resources. And then if we resolve that notice issue up front, then that's that. If you think that there needs to be additional facts developed about all of these other things that have resulted due to the lack of notice, then we can handle that. But I think notice, is just the baseline of everything here.
So, Mr. Holliday, there's been a new suggestion made that maybe some of this could be dealt through briefing before a hearing, which we'll schedule March 10th. It's not a problem. We'll hold it. I want to pull up the rule. Oh, wait, I have the. Mr. Holliday, what part of the rule are we dealing with here?
I believe we are dealing with, gosh, I have it written down here.
I'm guessing it's 1915-412 notice requirements.
Yes, sir.
Okay.
Yes, sir.
Under A compulsory pooling.
Right. This isn't the evidentiary hearing, and several arguments have been made by XTO. I'll try to keep mine procedural.
Sure.
But the question is whether the address to which certified mail was sent is the correct address. It is it is a commercially recognized and used address for XTO. And it's an address through which the parties submit JIBs and revenue, and the parties regularly transact through this address. And it's just not the preferred address for the land department. And that's the crux of the issue in both. Okay. That's the common issue to both cases.
So I'm looking at the rule. What I'm trying to figure out here is, do we have enough evidence already in the record to make legal briefing effective, or should we just wait to the hearing to receive the enough evidence to make a decision? And Miss McLean, what would you be arguing? What evidence is already in the record that you would feel briefing would be effective on?
I think their own hearing exhibits from the underlying cases, and then we would submit affidavits with email attachments that show that Riley's landman had been communicating with XTO's landman. In his signature block, there's, an address. He's sent stuff via email before, just no mention of any hearing whatsoever.
So, Mr. Holliday, I guess the idea here is we're basically reopening the original case, and there is a bunch of evidence that you submitted. Was it a hearing by affidavit?
Yes, I wasn't counsel on the prior case, but this was heard by affidavit, and yes, there were exhibits filed, and that's all in the record already.
So I guess, okay, now that I understand what we're doing, so do you feel it would be beneficial for the parties and for the division to do some sort of legal briefing and argument and potentially add additional evidence through affidavits. I mean, do you feel like we need to have a hearing at all based on what Ms. McLean is saying, or how do you feel?
I would prefer to keep the date on the docket. I do think that we could probably handle a lot of this through briefing.
Okay.
And then if we needed to have additional testimony beyond that, but I think a lot of this, I guess, yes, I do feel like we could probably handle this through briefing.
All right. Okay. That makes sense to me. You know, affidavits, you can't cross-examine affidavits, and I'm not going to be going back and forth with responses and replies. We'll take a legal brief from both parties if you want to attach additional evidence, Mr. Holliday. I know you do, Ms. McLean. Feel free. And we'll try to winnow the issues down or in some way reduce the scope of the hearing through your submissions. Does that sound fair, Mr. Holliday?
Yes, sir.
And Ms. McLean, does that sound fair to you?
Yes, I think that sounds good. Maybe setting a deadline for the briefs and then
Sure.
keeping the March 10th
Sure.
hearing.
Exactly. So why don't you suggest it's your case, Ms. McLean? What date do you want to set for the brief?
I would say to give enough time, so then we can have exhibits, you know, and all of that due.
Mhm.
How about February 20th?
Mr. Holliday.
I think that's fine. Hang on. Let me pull up my calendar.
It's about 20 days before the hearing. About 3 weeks.
Yeah, that's that's NAPE week, in Houston.
What week? What week?
The largest trade show for the industry is in Houston that week.
Oh.
If we could do it on the 24th, so close to her date, but give a little pad for that.
Ms.
That would be our
McLean, are
preference.
you going to attend this?
No.
You're not going. Okay. What did you call it, Mr. Holliday? What week?
It's NAPE, no, the North American Prospect Expo.
Oh, NAPE. All right, thank you. 24th,
Yeah, that's,
you're okay?
yes, that's fine.
Mr. Holliday, that date is acceptable to the division and to Ms. McLean. So we're not going to have responses to the briefs. We're not going to have replies to responses. We're just going to have the briefs so that I can take a look at this. Maybe I'll make a decision based on what relief you ask for in your briefing. Maybe I won't. Maybe I'll want to hear more evidence. I am going to involve the technical examiner, obviously, in looking at the evidence. I won't be making it purely on a legal standpoint. Okay, is there anything further, Mr. Holliday?
Nothing from Riley, no, sir.
All right. Ms. McLean, anything further?
Nothing from Exia. Thank you.
Fantastic, thank you. All right, we're off the record in those XTO cases. And Freya, would you please join that fourth case?
Yes.
I'm sorry, Mr. Examiner, can I ask a clarifying question?
Yes.
Did
go
we
right ahead.
decide to join
We
the
did.
25868 to
We did.
this? We did.
Yes.
Okay.
Yes, thank you for your argument. It seems to me that it would be more efficient to hear all four cases. If you want to submit a separate brief based on the separate issues that you see in that fourth case, Mr. Holliday, I'll accept it. And so Ms. McLean, I don't know, you guys can work this out between both of you. If you want to brief it separately, that fourth case, feel free if you feel the issues.
I mean, people always present things, you know, we can consolidate it for hearing.
Right.
And we can say, okay, now we're going to talk about Eagle and now we're going to talk about Marty.
Sure.
I'm not saying that like everything has to be addressed at the same time, but just for ease of administrative, you know, purposes, I think having them on the same day and submitting things together makes the most sense.
I completely agree, which is why I'm going to join the fourth case, but I am saying to Mr. Holliday and to you that if you feel like you want to brief that case separately because the facts lead you that way, I'm open to it.
Okay.
Okay?
Yes, sir. Thank you.
Yes, thank you, Mr. Holliday. We're off the record in those cases. Let's move on to Permian Resources. 25812, 25814.
Jackie McLean on behalf of Permian Resources.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating. And Coterra did file an objection to these cases and is sending out competing proposals because the Permian Resources Development Plan is going to strand some of Coterra's acreage. And the proposals are hopefully going to go out this week or early next week. And so that would mean that Coterra could file for what was previously the April 2nd docket, but now is March 26th. So Coterra could be ready for a contested hearing in April on one of the April dockets that are available.
Okay, thank you, Ms. Bennett. That answers all my questions. Ms. McLean.
Yes, that's what my understanding is. They're filing competing applications. We also would prefer an April contested hearing date.
Freya, did we send, I know we didn't send out any April, but I know you emailed someone some April dates. Do you know what they are?
I did send them out and we've since changed them because
Mhm.
April 7th is no longer available. So we have April 21st or April 28th.
Let me write it down. April 21st or 28th?
Yes.
Ms. McLean, they're your cases. I mean, for now, they're your cases. They're not joined yet with Coterra's cases. Which of those dates do you prefer?
I think I'm not 100% sure, but it sounded like either of those dates would work, but I would like to confirm with the client
Okay.
before we commit to one of those. And probably Ms. Bennett needs to do the same.
Okay. Well, okay, then I'll set a deadline to hear from both of you. What's next week sometime? That work for both of you?
Yes, that's perfect.
What day, Ms. Bennett? Next week?
How about a week from today?
Perfect. What is that date?
Let me look.
Thank you.
It is, it's January 29th.
January 29th.
Mhm.
Okay, so January 29, we will either set a pre-hearing order for April 21st or 28th, depending. First, 8. And Ms. Bennett, when you do file your cases, would you please file a motion to join them
I will.
with the other cases? Okay.
I will, for
Anything
sure.
else, Ms. Bennett?
Nothing for me. Thank you.
Ms. McLean?
Nothing for me.
All right, we're off the record in those cases. Now we have a Coterra case, 25813.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating.
Thank you.
And good morning, Caitlin Black on behalf of Ichthys Energy LLC.
Thank you.
And good morning, this is Jordan Kessler on behalf of EOG Resources.
Thank you. Ms. Luck, I didn't hear you or Ms. Kessler say that you had objected to this case.
Yes, my client has objected to this case.
you have.
because-
Ms.
Yes,
Kessler has not. Okay, thank you, Ms. Kessler. Ms. Luck, you objected, why?
my client sent competing well proposals, and so those went out last week. And
Okay.
at this point, we're looking at filing competing pooling application. So we would prefer an April contested hearing
Okay.
date.
Would your case make the March 26th notice docket? It would make that docket, okay. Ms. Kessler, would you be involved in a contested hearing?
Only in that we would be monitoring Mr. Hearing Examiner, so no preference regarding dates or anything like that.
Perfect. Thank you, Ms. Kessler. Okay, so Ms. Luck, same thing that I discussed with Ms. Bennett. Please file a motion to join your case. Will it be one or two cases?
I can't say quite yet how we're setting up the spacing unit, but at this point, I will file a motion to consolidate the cases when they're
Okay.
filed. Thank you.
Okay, perfect.
And Mr. Examiner?
Yes.
If I could just say a couple of things about
Yes.
this
By all means.
contested hearing that's coming up apparently. So I filed this application on behalf of Coterra in early December and, oh, sorry, thank you. And, Ichthys, who, Ms. Luck represents,
What, who?
Ichthys,
Ixis?
Ichthys.
Oh, I see it, yes.
They are proposing to pool acreage in which Coterra owns 100% and which Coterra is planning on developing in the near term. Coterra has rigs available. It's on the drilling schedule. They have obligations that are coming up in Q2 of 2026. So Coterra is ready and wants to drill this acreage and wants to limit the delay.
Right.
And I understand that, I understand that ICTHYS hasn't yet filed its application, so we aren't able to request an earlier setting. If I could, I would. Coterra supports ICTHYS's development of laterals that don't interfere or encroach on Coterra's acreage. So it's not a matter of Coterra, wanting to fight tooth and nail with ICTHYS. They just want to make sure that ICTHYS is not pulling over Coterra's 100%
Well,
owned
Ms.
acreage.
Ms. Bennett, it seems like we could set, I mean, if the proposals went out a week or so ago, that's early January, the month, early February. I don't understand why we couldn't set a March date and just notice Miss Luck's case by itself. I mean, I think that's possible. I don't see why we have to wait till the end of March to notice Miss Luck's case.
Well, under the division's rules, and I guess I'm not understanding your question.
But
Would
in other
the
words, if
Coterra
proposed-
cases go
If we
alone?
wait 30 days
Mhm.
from early January, that means early February. Ms. Luck could file her application or applications early February. And the 20 days notice from early February gives us maybe March 1st would be the earliest, and we could notice it by itself.
And I definitely don't want to disagree with a plan that could move this forward more quickly, but the division's rules do require that an applicant file an application 30 days in advance of a hearing, so there's two requirements. One, that the division give notice 20 days in advance, but the rules also require that a applicant file its application 30 days in advance of a hearing. So I don't think that Ms. Luck could meet that deadline. And I'm not trying to make her argument for her, but I do feel, strongly about the rules.
I'm fine with the rules
Yeah.
and I'm happy to comply with the rules, but if she files her application in early February, 30 days from early February is early March, right? We can have a hearing in March, is all I'm saying.
How would it get noticed on a docket?
Well, we would notice it for the special docket that we set it for.
The two special dockets are March 10th and March 24th.
Right.
I mean, I will let Ms. Luck.
I mean, it's
weigh in on
possible,
that.
right? You admit that it's possible.
I'm doing the math in my head.
Sure.
It is theoretically possible because I think she said the proposal letters were sent out January 15th, which would mean the 30 days would run on February 15th, which means that she could file on February
Right.
15th or
Right.
16th, which would be for March 16th, which would be in time for the March
24th.
24th.
Yes. So it's possible.
It's possible.
I'm just trying to work with your
Yeah, no, I
your
understand.
delay argument.
Yes, I totally understand. And I hadn't really thought about it in those terms.
I'm just trying to move this along. Ms. Luck?
Well, I'm in agreement with what the examiner has mentioned regarding the timing. It could be filed for the March 24th docket. However, before the hearing started, we did discuss the April 21st and the April 28th dates
Oh,
as being the potential
okay.
contested hearing dates. And it was my understanding that Coterra was in agreement with the April contested hearing dates before this hearing began.
Okay. Ms. Bennett?
Yeah, I didn't really appreciate the fact that we could have made the March 24th docket.
Trying to
So
be, trying to
No,
be flexible for you.
I totally appreciate that.
Sure.
And I did run the April date. I was under the impression that the April dates were April 21st and 27th. And I did run those dates by Coterra and they are available.
Okay.
But I will need to run the 28th by Coterra and just make sure that that works as well.
Why don't we just do the 21st?
That's great.
Okay. Ms. Luck, 21st of April?
Yes, that date works for my client. Thank you.
All right, wonderful. So case number 10 for Coterra will go on the April 10 docket. All right, anything further, Ms. Bennett?
Nothing further. Thank you.
You're welcome. FE Permian Operating 25815.
Sharon Shaheen on behalf of FE Permian.
It is FE?
Yes,
What does it stand for?
I believe it stands for Freedom Energy, but I'm not absolutely sure. It's an affiliate of Flat Creek.
Okay, got it. Thank you, Machine.
Jackie McLean on behalf of Permian Resources.
Thank you. And you objected, Ms. McLean?
Yes, we did.
Okay, for what purpose?
We are filing competing applications.
Okay. And have you sent out proposals?
We sent them out Tuesday.
Excellent. All right, thank you, Ms. McLean. Ms. Shaheen, how do you want to proceed?
Yes, we'd like to go ahead and get this on the schedule for a contested hearing. I believe March 24th might
Okay.
be the first date, but I do need to run that date by my client.
That's fine. We can do what we did by saying January 29 could be a deadline for you to notify the division. Does that work for you?
Now I'm getting an email from my client saying he would prefer the April dates, so the April 21st or the April 28th.
Well, we'd probably pick the 21st. So would you like to ask your client if April 21st works for them?
I've already asked him
You
whether those April dates work, and he did say that either would work.
All right, and Ms. McLean?
I need to double check with Permian Resources, but I can get back to you.
All right. When can you get back to us?
Probably I can email them today.
Okay.
And I can get back to you probably tomorrow.
Okay. I'll set it to January 29th.
Okay.
Deadline. If we don't hear from you, we'll issue a pre-hearing order for April 21st. If we do, we can adjust it to maybe the 28th if that works for your client as well.
Okay, that sounds good.
It sounds like it both work for Ms. Shaheen's client. Ms. Shaheen, anything further?
Not from FE Permian. Thank you.
Okay, thank you. Ms. McLean?
Nothing from Permian Resources.
All right, and Ms. McLean, would you file a motion to consolidate is it one case or?
I'm not
Not-
sure yet. And once we figure that out, we will do that and then we'll file a motion
Please.
to consolidate.
Please. So you're thinking of filing mid-February then?
Yes, probably for the March docket.
Okay.
Or for the April docket.
Got it. The early April docket, which I guess,
It's now March 26th.
there we go. There we
I think that's why I'm getting confused with that. Because I think it was an old
It was.
contested hearing
go. It
date.
was.
Okay,
It was. April 7th, I think, was the original
okay.
Thursday docket for hearing by affidavits, but I won't be here, and so we moved it to March 26th. Anything further, Ms. McLean?
Not from Permian
All right, Thank
Resources.
you. Now let's go on to Permian Resources. There are three cases, 25818, 19, and 20.
I guess Jackie McLean on behalf of Permian Resources.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating, and Coterra has filed an objection to these cases. Coterra does not need to file competing applications because it has a JOA, so it doesn't need to send out competing proposals or file a competing application. But the reason it objected is because one of the sections that Permian Resources is seeking to pool is 100% committed to Coterra under a JOA. And so Coterra wants to go to a contested hearing to protect its rights in the JOA acreage.
Now, before I go to you, Ms. Vance, so hold on a second. So let me make sure I understand this, because we've had a case like this before.
Mhm.
And I'm trying to think, I think Dana Hardy.
Fiero.
Yes, that represented one, and who was the other?
It was Permian Resources and MRC.
Oh, it
Paula.
was. But who
MRC
represented-
Permian.
Holland
We
and
did.
Hart.
Oh, so it was.
Holland
it
and
was
Hart.
Vance.
Yes.
And Adam Rankin, and they had an 80-acre piece. I think that's on appeal to the commission right now, isn't it, Miss Vance?
That's correct.
I thought so. They had a 80-acre piece of land that overlapped with, did you know about this case?
I have been reviewing the
Oh,
materials
excellent.
recently.
Okay, so then you know all about it.
I do.
I don't have to tell you. I thought I'd give you a tip so you could prepare.
Well, I actually, I mean, I was surprised to see how the division ruled in that case, given commission precedent that Ms. Hardy and I were both involved in, that came to the opposite conclusion
Okay.
than the division on appeal. So I'm interested to see how the MRC PR Permian
Yeah.
Resources cases plays out on appeal.
Sure.
But I also know in reviewing the order for the Fiero, and I'm not sure what the other case names were, I did see some factual differences
Uh-huh.
between the cases as well. So even if that decision does not get overturned by the Commission on De Novo Review, I think the outcome of this case
Okay.
will depend upon the facts.
Okay. Yeah, and one of the main facts that went toward the division's decision in that case was that at the time of the hearing, Ms. Vance's client or Mr. Rankin's client, I don't remember who it was, did not have a competing proposal.
I
They
under,
had a JOA for a vertical well,
Mhm.
and they were saying, no, you can't compulsory pool this area. Anyway, so maybe it'll be factually different.
It is.
Maybe it won't. Okay.
It is.
So there we have it. So anyway, not to say anything to you, Ms. Vance, but I know you want to enter an appearance, so go right ahead.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart. And we entered an appearance on behalf of MRC Permian Company. We're just monitoring.
Perfect. Thank you, Ms. Vance. So Ms. Bennett, no competing proposal, just objecting, maintaining the objection. Maybe you're negotiating at the same time?
Well, I should clarify that they have submitted proposals for the acreage under the JOA. It's just not the kind of proposals that you would normally expect to have in a pooling case because it doesn't trigger the 30-day requirement for notice and good faith negotiations under pooling cases. So they have proposed wells under the JOA and they have 2 wells that are currently operating under the JOA. So to say that they don't have competing proposals isn't necessarily accurate. They're just different than the type of proposals that the division is used to seeing because they're proposals under the JOA.
Thanks for clarifying that. Ms. McLean, how do you want to proceed?
We were hoping to request the April 28th hearing date.
That's as soon as you want, April 28th?
Yes, because I
Okay.
do believe that there are negotiations between the parties.
I figured there would. Okay.
And Mr. Hearing Examiner, I'll just need to double check that date with Coterra, but I think that will work.
Okay. So we'll issue a pre-hearing order for April 28th and then Ms. Bennett, if for some reason it doesn't work, please let me know.
I will.
Then Ms. McLean, April 21st would work for you if April 28th doesn't?
I would need to double check.
Right. Yeah, so we'll issue a pre-hearing order since you think it may work, Ms. Bennett. We're pretty close. But for not, we'll deal with it on your motion.
Thank you.
All right, thank you. So let me write that down. All right, we're off the record in those Permian cases. Let's move on.
I have one thing.
Yes, go ahead.
This is not to do with that case. I was just hoping in the rush of everything, for case 25790, that Alpha is withdrawing their objection. If we could go back to that
Yes.
really quick. I double checked and we actually did provide notice to everyone that we needed to.
Okay.
So could we continue it to the February docket for presentation by affidavit?
Yeah, let's see why.
Okay, thank you.
So you'll continue it to that docket. And Freya, would you give that one priority because it's been around for a while?
Yes,
All right, so what is the date in February, Freya?
it's the 5th.
5th, thank you. All right, so Ms. McLean, the 5th.
Thank you so
All right,
much.
you're welcome. Let's move on to Avant Operating 25827, 25829, 25831, and 25832.
Good morning, Mr. Examiner, Dina Bennett on behalf of Avant Operating 2 LLC.
Thank you.
And these cases are actually consolidated with the next
Many.
14, or I'm not sure how many Permian Resources.
Okay, let me
cases.
call them. But thank you, let me call them. I don't know why they're, so Freya, will you consolidate these 4 with the next Permian Resources cases?
Yes,
Thank you. I'm also going to call 25833, and I'm not going to read all these numbers, but it goes all the way to case 25845. These are cases 19 through 31 on our docket. And you've entered an appearance on all of them?
I did. I
Okay.
entered an appearance in all of Ms. McLean's cases and objected, and Ms. McLean entered an appearance in all of my cases and objected.
Ms. McLean?
Yes, Jackie McLean on behalf of Permian Resources for all of those many cases.
I think we have some other,
And
Yes.
Yes, Mr. Hearing Examiner, Caitlin Luck for WR Non-Op LLC and just appearing, not objecting.
perfect. Okay, so, but I called Ms. McLean's cases. No, I called Ms. Bennett's cases first. So Ms. Bennett, how do you want to proceed?
Thank you. The parties are in discussions, and as the division learned recently, Avant and Permian were able to resolve some objections to Avant's triple stamp development plan, leading to the vacating of a contested hearing next week. And I think both sets of parties remain hopeful that the same outcome will happen for these competing cases. But in the meantime, I do think it makes sense, and I've discussed this with Ms. McLean, that the cases be set for a contested hearing.
Which one? What date?
Well, there was some confusion this morning about dates, just in full
Yeah.
transparency. Yeah. But I have confirmed just now with Avant that 4/28 works for them.
Ms. McLean?
Yeah, I'm still waiting to
Oh.
get confirmation. And then we will,
Okay.
Finalize.
Back to these cases?
well, I think we're still waiting to hear from one person on the hearing availability for 4/21 or 4/28.
Okay.
So if we can get back to you by the January 29th, that would be helpful.
And you don't want a March hearing. You want to give yourself as much time to negotiate as possible. All right. Does the 21st work for you as well, Ms. Bennett?
That's where.
Your microphone.
That's where some of the confusion came
Oh, I
in.
see.
Ms. McLean and I had coordinated yesterday, and she had indicated that the 21st did not work for
Okay.
Permian. So I had only asked Avant about the 27th, now the 28th. So I've asked Avant about the 21st, but what they've been able to get back to me with is the 28th.
All right. Okay. And Ms. McLean, you have an email out to your client right now, waiting to hear back from them.
Yes.
Do you think you might hear by the end of today's hearing?
Let me text and
Great.
I'll see.
Great. All right. So. Avant versus Permian. And Ms. Bennett, what are the issues here?
These are overlapping or competing development plans. And so the issue to be resolved at the hearing would be who should be designated as operator of the acreage.
But what are the issues in other words, is this a difficult issue to negotiate, or do you think you'll be successful in negotiating it?
I haven't been involved in the
I'm not.
negotiations at all, so I'm not sure what the
Okay.
likelihood of success is or what hurdles might remain.
All right, so Ms. McLean, we'll tentatively set this for April 28th. If you hear from your client before the end of today's hearing, please let me know. Otherwise, we'll expect to hear from you by the 29th. Anything further, Ms. McLean?
Nothing from Permian Resources.
And Ms. Bennett?
Nothing further. Thank you.
All right, perfect. Thank you. Let's move on to Mewburn Oil. It looks like this is a solitary case, although I'm not sure. 25851.
Mr. Examiner,
Yes.
this is Jim Bruce entering an appearance on behalf of Mewburn. Sorry,
Okay,
I couldn't do it by paper.
That's okay. So, Mr. Bruce, is this case a standalone case? Because we have a Mewburn Oil 25852 right after.
I'm sorry, Mr. Examiner. Yeah, I'm involved in the other two. Thank you.
Would you like us to consolidate the two cases?
Well, what is it, 2521 or?
They're both Credence. The well name is Credence.
Yeah.
25851 and 52 are the case numbers.
Yes, I'd like to be enter an appearance in both cases.
And would you like us to join them?
Yes.
Okay, so Freya, would you join them?
Yes.
Thank you. Okay, thank you, Mr. Bruce. Who else do we have?
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating and Concho Oil and Gas, and we are objecting to this case.
You are objecting.
We will be filing competing applications in this case. And we plan to send our well proposals out next week.
Will you be representing?
I would like to hire outside counsel for this, but haven't done so yet. But good question, because this is an interesting posture for us to be taking.
Yes, I agree. And I think it would be refreshing to have you present the competing case
So I'm sure it will happen at some point.
at some point. Thank you, Ms. Hatley. Did you say you did send out competing proposals already?
We'll be sending them next week.
Will be sending next week. Okay. Okay, Mr. Bruce, how do you want to proceed?
Well, Mewburn would like to proceed as quickly as possible, but from what Ms. Hatley said, she probably can't get on the docket until April. Is that correct?
Yes, but we have the April 21st docket open and we have the 28th as well. I would prefer the April 21st docket for a contested
Then
hearing.
I would prefer the April 21st docket.
Okay. Ms. Hatley, April 21st?
Mr. Examiner, since Mr. Bruce just entered his appearance this morning and we haven't filed our well proposals yet, we would like to push it out a little bit further if that's possible.
I don't think we have dates yet. So why don't we do this? Why don't we set this for another status conference? Mr. Bruce, do you think negotiations will be fruitful in this situation?
Well, I hope. I do know they spoke last Friday together, so we shall see. And I will be talking with the client.
And Ms. Hatley, do you have any other information?
I don't. I always hope for an agreement if possible, but I think setting it for another status conference would be really appreciated.
All right. Okay, so Mr. Bruce, we do have April 21 and 28 as possible dates. Please keep those in mind, that these cases could be put on once we have our next status conference.
Okay.
So
what date will the status conference be?
I think February, a month from now, basically.
Okay, the 26th or something.
I think that's right. I think 26 is right. Yes.
Thank you.
Oh, thank you. Ms. Hatley, that works for you? All right, excellent. And by then you'll know when you will be filing, et cetera, et cetera.
We'll have a lot more information by the next status conference. Thank you, sir.
Exactly. Thank you, Ms. Hatley and Mr. Bruce. Feel better, Mr. Bruce. Okay, moving on to Spur Energy Partners. This is 25854 and 55. Entries, please.
Yes, Jackie McLean on behalf of Spur Energy Partners, and 25854 and 55 should not be consolidated. And yesterday we filed a motion to dismiss case number 25855.
All right, thank you. Appreciate the update.
Good morning, Mr. Hearing Examiner. Jacob Everhart with Beatty Wozniak, New Mexico, appearing on behalf of Hillcorp Energy Company. We are objecting to this case, moving forward by affidavit at this time.
And for what purpose are you objecting?
So Spur Energy's application is an overlapping spacing unit, and it overlaps 11 of Hillcorp's 11 existing vertical wells. So Hillcorp has considerable concerns with the design as proposed by Spur with regard to the potential for collision. I know to date, both parties have engaged in promising discussions regarding Spur's proposal, with Spur potentially offering some areas where they won't kind of frack to kind of shield against some of the offset collision. But at this time, we would request that we schedule another status conference for next month, the 26th, as things seem amenable to both parties.
Yeah, okay. Thank you. Ms. Kessler?
Sorry, I was muted. Good morning again, Mr. Examiner. Jordan Kessler on behalf of EOG. We're monitoring this case, not taking a position.
Perfect. Thank you, Ms. Kessler. So, Ms. McLean, those kind of issues sound like they're easy to resolve, don't they?
I'm not sure. I had reached out to Beatty and Wozniak Hillcorp's counsel last week, and I had never heard back. So this is the first time hearing. And the direction from my client is to set a contested hearing for March 10th or March 24th.
We can do March 10th. That's not a problem. So, Mr. How do you say, is Everhart? Yeah, there we go.
Yes, sir. Everhart.
Mr. Everhart, I do give the applicant the discretion and the leeway to get a case heard as soon as they can. She's asking for May 10 or May 24.
Oh, no, March.
That's what I meant.
For the record.
Now I have May out of my head. She is asking for March 10 or March 24. Your response?
Yeah, so this information came to us late last night from the client, so I apologize to Spur's counsel. But I think as an alternative, we would pursue a competing application, and we have not sent out proposals and things of that nature yet. So I would ask for a contested hearing to be scheduled after March.
Well, you haven't sent out proposals yet. So what I'm going to do is I'm going to set it for March 24 based on Ms. McLean's ask. If you do send out competing proposals, then we'll have to deal with potentially moving that date to a later date. But that'll be an argument that we hear at a later date. So it's only one case, 25854. Is that right, Ms. McLean?
That's correct.
That's number 34 on the docket. Okay, Mr. Everhart, good luck with your negotiations. I mean, you have 2 months. No, I guess you have 2 months to negotiate this or file a competing application. Ms.
Yes, sir.
McLean, anything further?
Nothing from us.
We'll issue a pre-hearing order for March 24th. Okay, we're off the record in those 2 cases. Thank you, Mr. Everhart. We're down to the wire here. Mewburn Oil, 25857, 6869 70 25858 and 59.
Good morning, Mr.
yeah.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant in the cases listed on the worksheet, which are the Buffalo Gap cases.
Thank you. Why are there more cases than are on the docket today?
So these are set for a contested hearing with Ms. McLean's Permian cases, Permian GTO cases. They're set for a contested hearing on February 10th. And we just wanted to have this status conference just to circle back. My understanding, and Ms. McLean and I talked earlier this week, but the parties are in negotiations and just wanted to provide an update to the division. So, possibly things could get resolved before that contested hearing date. So.
Okay, thank you, Ms. Vance. Ms. McLean? You want to answer your appearance first?
Yes, Jackie McLean on behalf of Permian Resources and case numbers 25768 through 25770 and 25857 through 25859. And yes, it's my understanding the parties are negotiating, but I'm not sure if they are going to come to a resolution. And so we're just proceeding forward at this point, like we're going to the hearing on February 10th.
Okay, all right. The deadline for pre-hearing statements and exhibits would be the week before, right?
Correct.
All right.
Next,
Correct.
it's February 4th at 9 a.m.
Perfect. So you obviously know what the deadline is. Is
Yeah.
there anything further, Ms. Vance, besides your rosy outlook on negotiations?
No, but I did want to circle back on the, if possible, on the first 2 cases on the worksheet. There also some other related to some other Mewburn Buffalo cases. And I got a further update. I know you had said that you were going to issue a pre-hearing order. We are going to file competing applications in that. So I just want to make the division aware that I'll be filing those and that we'll be requesting to consolidate those, be added to the pre-hearing order once we file those applications.
When do you think you'll be filing them?
In the next day or 2.
Okay, very soon. Okay, sounds good.
Yes.
So Ms. McLean, did you know that?
No, okay, no, and I'm confused. So they're filing applications for the February 10th contested hearing?
I thought it's March 10 is what I
March
have on my
10.
sheet. It was March 10, Ms. McLean.
Yeah.
And what cases are we talking?
The very first, sorry, we're recalling.
So confused.
On Mrs. Vance's request, we're recalling 25771 and 72 is the.
Okay, okay, got it. I thought we were
That's
still
okay.
on this one. Okay. Okay, so then what is?
I just wanted to let you know that she's filing competing applications in the next day or so.
Yeah.
Okay, And then are we still going to be getting back to you on, on March 10th or 24th? Is
No,
that?
we already
to be-
assumed March 10th.
Okay.
I didn't have anything noted down that you were going to get back to us.
Okay, thank you. I'm
You're
like,
welcome.
I don't know what we're talking
You're
about
welcome.
right now. There's
That's
been a
okay.
lot of dates thrown out there today.
That's okay. So,
Um,
Ms. Vance, back to your cases. Is there anything further on your cases?
No, we will keep the
Great.
division updated if anything changes.
Okay, wonderful. Ms. McLean?
Nothing from Permian
Wonderful. We're
Resources.
down to the last case of the day. This is XTO Energy 25868.
Yes, and Jackie McLean on behalf of XTO, and this was addressed with the case numbers 25807 through 25809. We'll be briefing the notice issue. This is the one that Ms. Chance referenced earlier.
Okay, so we've dealt with this case already.
Correct.
And I didn't realize that it was sitting out here at the end. Okay, that is it for the docket. I think we do have some time to talk about any challenges. Let me get a fresh.
I have an update
Oh,
on
you do? Okay,
what was it?
the big cases.
The spicy chicken
Yes.
cases.
Yes.
And it looks like only April 21st will work at this point.
Ms. Bennett?
Thank you, Mr. Examiner. As I mentioned yesterday, Ms. McLean, and I understand schedules change, but had indicated to me that April 21st did not work. So I have not, I have asked Avant about April 21st, but I don't have an answer from them because they are available on April 28th.
Right. Would you
But
ask?
I will ask, yeah.
Would you? Okay. Can you, I mean, I don't know if you're staying for any part of this discussion next, but if you could ask Avant now, and I understand that you may not get an answer, but maybe we will.
Yep, I will definitely ask. I know that one person is out in the field today, but I'm asking them right now.
Oh, that's great. And Ms. Bennett, we if we start on the 21st, it may go to the 22nd. And if one witness isn't available, maybe another expert could review. I mean, there's so many
Yes.
different options we have here.
Right, and I would suggest the same thing
Yeah.
to Ms. McLean,
Oh,
obviously.
Oh, of course, definitely.
But I am asking about April 21st right now.
Very good,
I just
thank you.
texted.
Appreciate
And then this is also affecting apparent metallic cat.
I don't
which
know what
is-
you're talking about. What?
It's another case that Miss Bennett is involved with, 25818 through 25820.
What
Um,
numbers on the docket were they?
This was
You can tell.
number. Thank you, Karen.
Please say again.
12, 13, and 14.
Okay, so we have Jackie McLean and we have Miss Bennett, pre-hearing order for the 28th. We can
Yeah.
have, yes.
But we need the 21st now. Apparently there's
On
a
that one too?
conflict, yes, with the 28th.
Oh. My. All right, and then Miss Bennett's representing Coterra, and is that the same part? No,
No, it's a
No.
different party. And
It's
I understand she'll need
Coterra.
to
Miss Bennett,
ask for dates for that.
so you're asking now to change the hearing from the 28th to the 21st. And Miss Bennett, what about your client's availability on the 21st?
My Coterra texted me that they're available on the 28th.
Would you
So
ask
I
them
will
about the
ask them,
21st?
they're listening
Oh, they
to the
are.
hearing and the landman from Coterra just texted that they cannot do the 21st.
For Coterra.
Mhm.
So okay, so hold on a second. So we can't do the 21st. What about the 22nd? Since they're listening. I mean, because we could start on the 21st and continue to the 22nd. We could also, Miss Bennett, for your client, if necessary, if it's just the landman who's not available, we can come back on the 28th and get the testimony from your landman at the 28th as well.
Yeah, I'm checking.
Yes, thank you.
And if we're gonna be doing like all of these cases, there's no way they're gonna be done
Yeah,
on
of course,
one day.
Of course.
But yeah, apologies. I'm just getting this
Sure.
information. The landman who is doing all the negotiations and deals and everything and interfacing with Coterra's wife has a trial. And he cannot travel to Santa Fe or be available as he has to take care of his child. And we
see.
know how
Okay.
trial can be.
All right. Well, Okay, so we're gonna wait and hear from Ms. Bennett to see what her client can do. While we wait, I thought we could use this time effectively to continue our discussions from December, where I asked council what challenges they were having with the new systems that we put in place. So the first issue is, let's talk about amendment cases. Now, I'm still seeing amendment cases on our dockets. We have a bunch, right, Freya, for February?
I believe so. I think we also received some for the March docket as well.
So it sounds like they're still being filed, the amendment cases. And if there's a reason to file them, that's fine. But I'm wondering, why are we still seeing this many amendment cases coming to hearing? Ms. McLean?
Well, I just, I'm about to, for the first time, submit a letter requesting an extension instead of coming to hearing. We just got, I think I emailed everyone responses that we got from John Garcia, like over Christmas break, maybe. So this would be, the first kind of round of applications where we had received that guidance. And we're planning to, file the administrative way that he advised us.
Okay, so then you're not having any problems necessarily with now the new understanding that you have. You're fine.
I'm going to see. It's TBD at this point. I am planning on utilizing that mechanism that Mr. Garcia set out in his clarifications to us. But, at this point, it's very new in the process. I don't expect there will be any issues with it, but we're giving it a go.
The reason I'm asking is because we're still seeing amendment cases, and I wondered why. So basically what you're saying to me is, well, we're just starting to implement the new process now.
Yes, and then it also doesn't resolve amendment cases if we need to add additional parties or pull additional interest owners. So you're still going to see some amendment cases if we need to come back and do that. This should just resolve the 1-year extensions.
And I wasn't really thinking that we would stop seeing amendment cases altogether because of what you just said. But then there's that new language in the orders, those new paragraphs in the orders that we just saw last month. I saw for the first time last month. Does that change anything for you?
Not that I'm aware of.
Ms. Bennett?
Thank you. In terms of the reason why you might still see some extension cases is because the orders were issued before the new language was added to the current orders. So I'm not entirely sure when that new language was added, but there could be some orders that predate the, in fact, one of the extension cases I filed for the December docket or this January 8th docket did not have that language in it.
But are you saying that you need that? Are you saying that if you don't have that new language in there, that the division's direction would somehow not suffice?
Well, the prior form of order said that you had to, under the prior form of order, the practice was to apply for an extension and to show good cause.
Right.
And that, so it's an inconsistency between the prior form of order and the new form of order. And so if the division desires to have only even old forms of order submitted through the new process, that can be done, but I would say it's inconsistent with the form of order.
But I mean, good cause is usually in the landman's self-affirmed statement, which is evidence. I mean, it would seem to me that if you don't have any protests on your extension of time, even with the old language, you could still show good cause through that. I'll call it an affidavit. I know it's not, but right?
You could.
Okay, you could.
Mhm.
It's possible.
Yep.
Ms. Vance, I'll get to you in just a moment. I'm just going around the room. Ms. Hatley, any issues with you don't do extensions, do you? You never do extensions, do you?
We do, but
You do.
we haven't filed any recently, and
Okay.
I don't know if we have any coming up, so I defer to other council's opinions on this matter.
But you knew that there was a change, right?
Yes.
You knew there was a change. Do you have any issues with the change?
No, sir.
All right, good. Ms. Shaheen?
Thank you. I haven't filed an application for an extension in quite some time and don't anticipate any in the interim, but I'm paying attention and will take it all into consideration when I do.
Thank you, Ms. Shaheen. Ms. Pena? All right, so you, in other words, you're fine. Ms. Vance, any issues on amendments?
I'm sorry, I was on the phone, so I missed some of the conversation, so hopefully I'm not repeating. We're getting ready to do a administrative filing for a request for extension.
Great.
We're gonna test it out, so we'll see how that goes. I don't know if
Okay.
anyone else has, but we are working on that.
All right.
Yeah,
Okay.
we'll see how it
Now
goes.
I'm going to ask about the additional information that's being entered for a request for a hearing. So Ms. McLean, I know in the past you've had issues with entering information. We changed our system to not require a pool code. Although I think there's discussion about that somehow coming back. No, really, there's discussion, but it's not now. So are you having any other issues entering applications for requests for a hearing based on the new guidance?
Yeah, it's just very expensive.
I knew it would be.
I think though that the pool
Yeah,
situation.
yeah.
Continues to be a overwhelming problem in so many ways. Just this week, we were told, or we had to go back to a hearing because the division during the hearing told us that it was a gas pool. So then we went back to hearing, we said we're going to file an NSP, an NSL for those wells. We filed the NSP and now we're being told it's not a gas pool and we really need an NSP. So the requirement that we put in a pool or that cases are being pushed out because of the wrong pool just really is creating so much burden on the client. We're spending thousands of dollars. I mean, and of course, these are huge companies, but still, it's, thousands of dollars.
What's your solution? What's your solution?
The division needs to just provide the pool with the order themselves. That is the only solution I can see in this, is that when they're reviewing the applications, and they make the final determination on it. We don't need to put it in the checklist. And if they do decide that it is a gas pool and we've proceeded as it's, an oil pool, then they just tell us go administratively apply for these things rather than making us come back to a hearing, because it's really creating, and it's almost unworkable in some situations.
That's why I'm asking you.
And I think, that could be really helpful for everyone, and you're not reviewing exhibits, then, it's just.
And what about and he's not with us today, but what about what Mr. McClure said last time, which is send an email to get the pool code from tech? Oh, you do that?
We've done that.
Oh, you do that?
Yes.
And that doesn't work?
Because then it changes somehow between then and the hearing.
Okay. I mean, I know it happened in one case, but are you saying?
It's been in many cases, many instances. Because it seems it's not just Mr. McClure who is giving the pools at this point. There's a lot of people weighing in on this, and that's making it more difficult.
Okay. This is good because we have a weekly meeting now between the hearing bureau and the technical bureau. And this is a main issue. And so we have to find a way that this doesn't keep happening to the applicants, because you're right, it's a waste of time and money for everyone.
Or make them publicly available online. That could be really there
must be a reason why that's not being done, right?
I have no idea why it's not.
Really?
No one has given us an answer. It's my understanding people have IPRA'd them, and then that was looked down upon. So no one's doing that anymore. But, they have well information already publicly available. This doesn't seem proprietary in any way. Just having it on the website would make things easier. And these guys that are looking it up know how to use all that stuff. I would never be able to go and search, but someone could that knows how to use that system. But that, that could be a very easy solution. Just make it available.
So so what I hear from you is it's time consuming to enter information. I don't think that can be helped, but the pool code thing is like a flaw that we should try to fix here at the division level. Thank you. Ms. Bennett?
Thanks. Yeah. I definitely agree with Ms. McLean on the making the pool codes publicly available. It is very frustrating to think you have the right pool code and then find out that you don't have the right pool code. I disagree a little bit with the idea that it would be the division applying it at the order phase, because we do need to know whether it's an oil pool or a gas pool as we're preparing the application. But I appreciate her suggestion that if it turned out to be the wrong type of pool, we could fix that administratively instead of coming back to hearing. That would really relieve the burden on the division and the applicant to, have multiple hearing packets coming back to the division for just what is a cleanup that is completely outside of the applicant's control. I'm not saying it's always outside of their control. I will say that there have been times when, we don't know what the pool code is. And so we look at a well that's in an adjoining unit and say, okay, that's got to be the pool code. And then it turns out it's not. So it's, it isn't always that the applicants double check with engineering or with Mr. McClure. There's some information that's publicly available that we use to infer what the pool code is. And that also has seemed to me to be workable most of the time, because it does relieve a burden from constantly bombarding the division with questions about the pool and pool code. But if it was publicly available, we wouldn't even have to do that. And in terms of the filing, I filed a few applications and I feel like it's
Workable?
workable.
Okay.
Mhm. Thank
Thank
you. Thanks for asking.
Yeah, definitely. Yeah, Ms. Hatley? Machine?
Thank you. I think it's workable. I do have, I understand that we're not going to get penalized if we put something in there incorrectly, and I really appreciate that. I do have one question about the locations, because I believe there's 2 entries that ask about location. The first one requires a unit letter, and for that one, we've been putting in the surface hole location. The other location does not
You're going
require.
way too fast for me.
Oh,
I'm
I'm
trying to
sorry.
write this down.
I'm sorry.
Surface hole location?
So for that first request for location
Yes.
information, we use the surface hole
Right.
location because
Got
it
it.
asks for the unit letter.
What
This-
do you mean by unit letter?
Well, if you go on the GIS
I'm
web,
not, so,
if you go on the GIS website,
yes.
you'll see, there's the townships, ranges, sections, and then you can see that they've divided each section into
Letters.
letters.
Okay,
16 maybe.
okay.
That
40 acre
40-acre
United
tracts.
States
That's right.
letters. I see. Okay.
Maybe it's 6 times 4, 24.
No.
No,
4 times
4 times 4. My math
Yeah.
is not great.
Yeah.
So it says letter, unit
Okay.
A, unit B.
Location, surface hole location is one letter. Okay.
Yes. And so then when it asks for a location in another entry, and I apologize, I can't tell you which entry it is
Okay.
because my assistant does it. We've been putting the location of the spacing unit
Okay.
as best we can, or at least part of the spacing unit. So I guess it would be helpful to have clarification as to what location information they
Just a
want
second.
for each of the entries.
Oh, for both of them.
Well,
Okay.
we can assume that the first one, I guess, is the surface hole. But is that what they want for the second one? Because it's redundant if it is.
That's why I'm asking the question. I need to know what the issues are. All right. I'll take that back to the technical team. Does anyone in here know the answer for machine? No, it's a mystery to everyone.
Yeah, we just use whatever location is the one in front of us.
Wow.
Yeah, because it is duplicative. There, when I do it and my assistant does it, we end up putting the same information in each of those fields. I don't think we use the surface hole location for the first one. We use the location, we probably use the first take point. I would say it's inconsistent.
I do. What I've done is because sometimes like well, it won't let you put in a lot.
Yeah.
So I'll just like choose whatever like fits because there's no other option. So that's
Wow, this is interesting that this has been a mystery this long, and I'm just hearing about it now. I'm glad I asked. Ms. Vance?
Yeah, I echo everything that's been said. I do agree with Miss Bennett on the, getting the pool information up front so that we know exactly what our building blocks are. It would be nice if the pool information was publicly available, but my understanding is that sometimes the pools get reassigned or
Sure.
they change, and that's
Exactly.
why that information is not public. Yeah, I do appreciate if we can keep that, including the pool as a part of the filing process. And then also, it looks like, we no longer have to include the facility information, which, that obviously a lot of times we don't know what that is. So yeah, that's, we've been putting for, in terms of what we've been putting for the location, we just put the surface hole location. That's all we've been using.
Oh, you do? Okay.
Yeah.
All right. Ms. Pena, anything? Nothing from you, Ms. Pena. Okay. And then there was a third notice, and I have forgotten what that was. Can anyone tell me what the third notice was?
Yes, Mr. Examiner, that was the new notice exhibit that
Oh, yes.
includes the committed versus uncommitted and how committed.
So I'll start with you, Ms. Bennett. How's that going?
Fine.
Fine. Okay. Miss McLean? I know you had a problem with it last time.
I think we're trying to figure out like a different way to do it.
Oh, okay.
And we're hoping, well, we're going to try this next go around to just add that information onto one of the already existing exhibits from the landman instead of like create a whole new one in the hopes that that will take care of that.
We'll find out.
Yes.
Miss Hatley? No. Machine?
Nothing from me there. We've been successful so
Good.
far in that
That's
front.
good to hear. Thank you. Ms. Pena? Nothing. Ms. Vance? About the new exhibit with the
Yeah,
whether it's voluntary or involuntary or.
we have just worked with our clients to ask them to
Okay.
include the type of commitment, whether they're voluntary, involuntary, et cetera. And then I did confirm with Mr. McClure, it's my understanding, we don't have to, because he understands that we're the ones doing the notice, we don't
Right.
have to include that additional information. So just the 2 columns with the type of commitment, whether they are committed or not committed,
Okay.
we're fine with that. We're working with it. So
Good.
no issue.
Good. Yeah, thanks for sharing, Ms. Vance. Okay, now I saw some stuff going. I saw some stuff going back and forth, so we're gonna go back on the record and let's talk about cases 12 through 14, which are Ms. McLean's Permian Resources cases that are gonna compete with Ms. Bennett's Coterra cases. We had a pre-hearing order that was going to be for the 28th. Then Ms. McLean asked for the 21st. Where are we now?
Now we are at a status conference in February
All right.
and a early May hearing date.
All right, I can deal with that.
What is the
know.
May?
Let me
Do we know that?
Freya, do we have any early May dates?
What I have right now would be May 12th.
May 12th.
I think that could be.
That works?
Yes.
All right, Ms. Bennett?
I think that'll work. The reason why we weren't able to.
That's okay.
Okay, okay.
And
Great.
normally I wouldn't set it out that far, but I just really want to get this set.
Yeah, us too. So thank you.
At this point, I just want to get it set. So we'll issue a pre-hearing order for May 12th. You will file your continuances for the February 26th docket. Ms. Bennett, will you have case numbers by that point?
I'm not going to be filing a competing application. This is the one. Mhm.
Yes,
Yeah.
yes. Okay, got it.
And then, Mr. Examiner, if we
Yes.
could recall
I'm
the,
going to, yes.
Thank you.
The Avant cases with the Permian cases, yeah, that's numbers 15 all the way to 31. I won't go into numbers right now.
Thank you. I've coordinated with Avant and they are available on April 21st.
Well, thank you. April 21st, and Ms. McLean, that works for you?
That works for us too.
That's great.
And
Okay,
then I
cool.
also have one more, for, it is, let me find it here. The FE Permian 25815.
Let me find it, hold on. Without a line number, I have to look through okay, that was number 11.
Yes, and April 21st does work for Permian Resources.
Excellent, and that, Ms. Shaheen, did you say that that works for you too?
Yes, I did.
Oh, wonderful, all right, we'll issue a pre-hearing order for April 21st, and we won't wait for your January 29 emails. Thank you, that's efficient. All right, is there anything else?
Nothing.
Nothing.
Thank you.
Excellent, well,
Do you
thank you.
want more stuff?
We're off the record.
Thank you.